Good morning. My name is Aaron King. The case study that I will be going over is Palmer versus Merluzzi. Dan Palmer, a student athlete at Hunterdon High School, who claimed that his constitutional rights to due process and equal protection were not given to him with a suspension that was given to him by Superintendent Peter Merluzzi, brought this court case to light. This court case examines the depth of due process in the educational realm and sets a precedent for what is justified to carry out disciplinary actions in a legal manner. The background of this court case is as follows. On September 1986, the plaintiff Dan Palmer was enrolled in a careers in broadcasting technology class at Hunterdon High School. He was given an assignment to use the school radio station, which would have been under no supervision. So he had complete freedom to go use the equipment. The morning after Palmer and classmates were using the radio station, remnants of beer and marijuana and a marijuana pipe were found in the radio station where Dan and his classmates were using the equipment and doing the assignment at. Palmer was ushered to the office of the school disciplinarian, Dr. Grimm, in which he and the football coach, Mr. Buckley, spoke to Dan of their findings. During this sit-down, Dan admitted that he had smoked marijuana and consumed alcohol at the radio station, which was on school grounds. The discipline handed out for this action was a 10-day out-of-school suspension. As the suspension was ending, the superintendent, Peter Merluzzi, decided to add additional sanctions of 60 days on top of the 10 that he had already served. This also included being suspended from extracurricular activities for all of the guilty parties, including Dan Palmer. The parents of Daniel Palmer protested this as it could hurt their son's chances of receiving a college scholarship for football. They were unsuccessful in front of the board, so they took it up with the New Jersey State Commissioner of Education, and it was looked over by Administrative Law Judge Bruce R. Campbell. When looking into this case, it comes down to whether or not two sanctions being handed out to Palmer at different separate times were done so in a way that his due process was not jeopardized. The Due Process Clause is part of the 14th Amendment of the United States Constitution. The biggest precedent case that was used in this case was Goss v. Lopez, which took place in 1975. This case started that a due process was required when a student faced a 10-day scholastic suspension. There was no doubt that this was done with the meeting the day after the incident with Dr. Grimm, Mr. Buckley, and Dan. The question is whether or not this was enough due process to warrant a 60-day suspension from athletics as well. Should he have been given a written or oral notice that his football eligibility was also in jeopardy? In Goss v. Lopez, the loss of the benefit of the educational process was a big reason that a written or oral notice needs to be done. Another question would be whether or not participation on the football team is part of the educational process. So being part of an extracurricular activity, does that count as a school-wide function or a school-wide activity that inherits the educational process? Seeing as it is an extracurricular activity and it is not a mandatory activity, it is not protected under the 14th Amendment as participating in school would actually be. Between this and the fact that Daniel Palmer's actions were enough for the school needing to maintain order and discipline, the court ruled in favor of the defendants. In conclusion, the court decided that Palmer received the adequate level of due process given the day after the initial incident by Dr. Grimm and Mr. Buckley. The court set the precedent that disciplinary actions must be carried out with either a written or oral notice before they are enforced. Thank you.